Welcome everyone to this webinar. My name is Laura Nee and I will be your host for today's webinar. As far as the logistics are concerned, what we have today is an informational webinar. You are in listen-only mode, so you don't have to worry about putting yourselves on mute. We do encourage you to ask questions. We do really want this to be an interactive webinar, so you can use the Q&A feature within Zoom to ask and type your questions, and we will actually take them as we go through the presentation. As far as the agenda, I will give you an introduction to our company, the Simplex Group, and then I will also give you some background as far as our guest speaker, David Scotti. David is going to be presenting the majority of the webinar on the impact of COVID-19 on existing and future construction contracts. So we actually started out providing a series of webinars. This is actually the second of the series. The first webinar series was focused on construction scheduling and how to incorporate COVID-19 delays into your schedules. So today's webinar is going to be more of a focus on the construction law/contract aspect of the impact of COVID-19. And I'll go ahead and introduce you to our speaker in a moment. We are going to have a Q&A session at the end. However, please feel free to ask questions as we go throughout the presentation so that we can make this an interactive session. We will be recording this webinar, and by registering, you'll have access to it. So we're going to go ahead and get started. A little bit about our company, my company, the Simplex Group. We have been in business for over 35 years, delivering project management solutions to the engineering and construction industries. We got our start as a reseller for Primavera, which many of you know or are familiar with, Primavera's scheduling tools and contract management tools. In 2008, we launched our own project management system called VPO, and we continue to provide VPO as a construction cloud-based project management tool in the Microsoft Office 365 suite. We have the ability to work with all different types of customers. Primarily, we work with owner organizations and construction management firms to provide a collaborative environment among companies managing documentation associated with their projects, as well as workflows like RFIs, submittals, change orders, and more. So today, I would like to introduce you to our guest speaker, David Scotti. David and I have done a lot of joint presentations together, and I thought it was only appropriate to invite him to speak to our customers and companies that are involved with construction projects. Now, David and I spoke at the American Bar Association conference in Arizona many years ago. We've known each other for over 10 years. We've done a lot of joint presentations in our hometown of Pittsburgh, Pennsylvania as well. So this is our first online presentation. So please bear with us. But, you know, what I think that David's experience really brings to the table, which I really wanted to have him talk with you, is he really, you know, understands the construction industry. I've always been impressed with David's ability to, you know, understand everything about construction and really formulate it into and look at it from a lawyer's perspective. So David has many years of experience working with construction companies, owners, contractors, a lot of different types of firms. And I thought that it would be good for him to talk to us about the potential impacts that COVID-19 may have from a legal perspective. So you're going to hear things like change orders and potential change orders and things that you have to think about and consider from a contracts perspective in the construction industry, not only for your existing contracts, but also for future contracts and how you can manipulate or how you can edit those and really be prepared for where we are today. So before I turn it over to David, I always like to understand who is in our audience today. So we're going to have several poll questions, but the first one is who's in the audience? What role does your organization fit in within construction? So we just need to know or would like to know who we have in the audience today. So I'm going to launch the first poll. And if you could, when you have a pop-up window come up, just answer what type of organization you're with. And then I'll share the results. So we'll just give it a few more seconds. Let's see if people are still voting. Well, and it seems to be quite a good mix of people from all areas, so from owners to construction management firms, architect firms, contractors, and lawyers. So thank you very much for participating in that. So I'm going to turn the presentation over to David, and he will go ahead and share his screen and give you some background as to his background, I should say. So go ahead, David.
All right, hopefully that worked.
It worked.
Good afternoon. I'm going to talk to you today about review and drafting construction contracts in the age of COVID. My goal today, okay, Laura, first fun thing. It's not a
click on the PowerPoint presentation. I think you just have to page down. There you go.
All right. So I want you to help you become aware of some of the issues that are going to affect your review and drafting of contracts. You have existing projects with existing contracts, and they're going to read differently to you in light of what's been occurring. Pennsylvania is a little more dramatic than some of the other states because we actually have been completely shut down for 2 months. And so we're just starting to get back up to speed again. And so we're going from a dead stop. You may have an impacted project that you're dealing with. So I want to talk about restarting or running your project in light of what's occurring. Your contract language is going to read differently. There's going to be some language that's going to apply and it's going to make things easy in terms of a transition. There's going to be other language that doesn't quite cover what you need or that maybe should be deleted. To accomplish this, you're going to need a change order, and you're also going to want to react to change orders depending on where you're sitting. If you're an owner, you're going to want a change order to update your contract to deal with the current situation. As a contractor, you may want to have a change order to not only update your contract, but to look for maybe additional time or money because of what's occurred. Also, when you go to draft a contract into the future, it's going to look different. And so you need to be aware of that. So as an owner, if you're getting ready to restart or run a project under these conditions, you have to evaluate where you stand. Where's your schedule? Where are you in terms of procurement? Are you having difficulties, not having difficulties with the job? Have you begun to notice problems with supply chain issues? You need to review your contract, again, as I discussed, to determine what has to be adjusted because of COVID. There are many, many, many seminars out there on COVID in terms of what's required. You're to look to the CDC, to OSHA, to orders from your state government, local laws and regs, and in order to help educate you on what's required. And unfortunately, that's changing on almost a daily basis. So you want to status your contract in order to know where it stands. And in order to do that, I don't have your contract in front of me, but I've decided that what I want to do is I want to use a form contract as a guide and then run through that form contract in order to allow you to appreciate the different issues that need to be addressed. I like form contracts because if you have a negotiation or you have a litigation and you put the contract in front of the other side, the period of review is sped up. They know generally what's in it, whether it's a judge or a lawyer or a contractor, and they look to the changes in the standard contract and you have a certain level of comfort as to what the deal is. And so I think that helps. For purposes of discussion, I want to talk about the A201 general conditions. It's one of the most commonly used documents in the construction industry. It's been around for a long time. It was first published in 1911. It gets updated every 10 years. We're presently in the 17th edition, and most recently was published in 2017. It will allow you to go through all the food groups of what we want to talk about. The general terms that are used in the A201 are generally recognized across the industry, so that if you use those terms, it's going to make sense to the other side or to whoever you're going to be dealing with. And obviously, you combine your A201 with some other form in order to create your entire contract. At this point, we have a poll question, and I guess I'd like to know how many of you currently use the A201 on any of your projects. And the questionnaire is up in front of you.
Yeah, we're getting some results in. We're almost there. And again, I did forget to reiterate, if you do have questions about anything that Dave has is going through, please feel free to use the Q&A feature and type in your question. So it looks as though the majority of the group has used the A201, Dave.
Great. All right. So for a contractor, when you're looking to restart your project, if you're looking at it in light of where things are today, if you've had your project continue to go on, you've come to realize that you're impacted. Your project schedule may no longer properly reflect the conditions. I guess Dom DeSalvo talked in length about that, and I guess his presentation is still available. But you need to update your schedule. You need to look at the costs that you've incurred. Again, if you had to demobilize and remobilize, if you had general conditions that existed during the time that you were shut down, you may have costs of materials that have gone up. You may have labor issues or labor costs that have gone up. You need to consider those, and then you need to decide whether you need to amend your contract, especially in light of what is being required of you under the CDC. So you're going to have added responsibility. So you want to look to amend the language. You want to review your insurance coverages to see whether or not you have any holes in coverage as a result of this. And then you also want to think about contingencies, because there's going to be more uncertainty. There may be future shutdowns that occur. You may have a COVID-related incident that shuts the project down. You may have supply chain issues. And so you have contingencies that need to be thought about.
Dave, I think there is a question.
Sure.
Will you be able to share the presentation slides with us? I know that we are sharing the video of this presentation, but will you be able to share the PowerPoint slides?
Sure. If you send your information or your request to Laura or myself, we can send you the slides. Not a problem. So what needs to be added to the contract? So again, you have your CDC, your OSHA, your state requirements of COVID. You have notices that have to be posted. You need a contractor plan of how you're going to address COVID, such as taking temperatures, asking questions. And I would like to remind you that doing all that in terms of testing and record keeping only has a value if you save it, if you have some way to recall it if there's an issue. A week, 2 weeks, a month from now, you may need to know who all was tested on a certain date and what the answers to their questions were in order to establish whether or not you knew or should have known that somebody had COVID of your employees. And if you don't maintain records, you're not going to be able to do that. Same thing with answering questions. You can create something that can be saved and you can put it somewhere so that it can come back to you later. I had advised clients during the shutdown that you had to track your added costs and how this was impacting you. Just like for a change order, if you don't have the documentation to establish how you were impacted, what your costs were, it makes it much more difficult to make a claim. Also, you're going to have a designated representative for COVID, which I assume would probably be the same as your safety representative. We've already talked about insurance coverage. You also need an action plan, and this is both for contractor and owner. If someone is diagnosed with COVID on the job, or you learn that someone who's been on your job has COVID, you need to have a plan in place so you can implement it. You don't need to invent that on the fly. Going through the A201, there are a lot of provisions that are affected or that touch on COVID. And I'm going to go through them rather quickly. And I'm going to skip this and just go to the slides themselves. But this gives you a sense of how pervasive it is. If you do a search of the A201 for the word delay, you come up with 26 different references. One of the things you're going to see or have seen is owners, for instance, if there's someone that owns a restaurant that's being renovated, the contractor may have reasonable concern as to whether they still have the finances in order to complete the project. Again, under the A201, you're allowed to ask that question and be able to have some comfort level that there is the money there to do your job. The A201 requires the contractor to comply with applicable laws, statutes, ordinances, codes, and lawful orders of public authorities. And this is significant because this is going to pick up the edicts that we get from the government, from your governor, etc. And so that is going to be something that the contractor has to comply with. Under the contract, the contractor's construction schedule, it's section 3.10.1, has to be revised at appropriate intervals as required by the condition of the work and the project. And simply stated, we're there. We have something that's going to require them to look at their schedule and determine whether or not it does need to be adjusted. Also, as part of this, the contractor is to submit a submittal schedule, which is supposed to tie to the construction schedule. And both with the change in the construction schedule and with procurement issues, there's going to be a need for the contractor to review their submittal schedule. The A201 requires protection of persons and property, and it requires the contractor to be responsible for safety. And again, this includes lawful orders of public authorities. The CDC guidelines specifically assign the responsibility for COVID-19 to the contractor. This is a provision which may or may not have been used by anyone to this point. An owner is able to suspend their project for convenience at any time for no reason. This is something that may make sense depending on where you are with your financing or what's happening in the community. If you're not officially shut down, but you feel that you're so hampered that you may want to take a time out and gauge the situation better. Under the A201, when you restart, though, the time will be adjusted for increases in costs and time, and those increases would include the profit level for the contractor. An interesting provision in the A201, it deals with loss of use insurance, and normally it seems to be reasonable. It gives the owner the option to go out and purchase loss of use insurance, and as a result of that, there's a waiver. It says that the owner waives all right of action against the contractor and architect for loss of use of the owner's property due to fire or other hazards, however caused. So you have a full-blown waiver, even though you have a situation where you may not be able to buy loss of use insurance that has any meaning. Virtually all loss of use policies and business interruption policies have an exclusion for microorganisms and for viruses, and therefore they're not going to do you any good. I've seen different articles and presentations where people are going through gymnastics to try and find ways around this. Talking to some insurance carriers, what they say is basically they feel as though the government is going to protect them, because if they suddenly become the ones that have to pay out all the money for COVID-related problems, they'll go out of business. So I don't know that you can count on getting much relief under your insurance policies. Now we're up to our next poll question, which is, have any of you experienced delays on your projects as a result of COVID-19?
And we're launching now. So far, it looks like a lot of people have. I'll share the results in just a moment. It's overwhelmingly yes, unfortunately.
And I can tell you, as an attorney, I got the phone call, have a client who had a worker who was diagnosed with COVID-19. On Friday, he was at the job, didn't have a fever, didn't have symptoms. Over the weekend, he became symptomatic. He was told to stay home. He tested positive. And then we went into the fire drill, and this is a while ago when it was newer, as far as what had to be done. And so you don't want to find yourself perusing all of the guidelines and all the bulletins and notices and articles that are out there. You want to have already figured out what you are required to do and what you want to do in the event that you have someone who has experienced this. So I feel a change order coming on, and so the owner is going to need to look to prepare a change order. And the owner needs to do that in order to revise the contract to address what we've been talking about with COVID. There's going to be a need to update, revise the construction schedule, the submittal schedule. There may be a need to look at insurance coverages. Also, you are probably going to be reviewing a change order from the contractor, who's going to be looking for additional time and additional money. So a contractor requested change order, what can you expect to see included? Costs, again, in Pennsylvania, since we shut down, demobilization, remobilization, costs of shutdown, extended general conditions. You're going to have a loss of productivity due to cleaning, due to what happens if you're sharing tools, and limitations in terms of occupying certain rooms in order to allow for social distancing. It's going to impede your progress. You may have staffing difficulties. You may have workers who are experienced people who aren't coming back to work. Or you may have people who have to go home for 14 days because they're starting to show symptoms. You're going to have supply chain disruption, material increases, and personal protection equipment is going to have to be purchased and made available to the people. These all have costs.
Dave, quick question. How does a contractor quantify those things from a documentation perspective, or how do you see that happening?
Well, again, it's dollars and cents. Let me back up a slide. So you're going to have hopefully a category that captures demob and remob and costs regarding shutdown. You're going to have your cost report that's going to do that. Staffing difficulties is a little bit trickier. You're going to have to keep some kind of a record of what you've gone through because of COVID, because you're going to try and create some level of a record to establish that you've been impeded. Supply chain disruption, you have intended dates when stuff is supposed to show up, and now you have changes. You have lack of material, delay in providing. If you've got equipment coming from China, you've got some bad issues. You're going to have material costs that you had planned on, and then you're going to have increases. And again, personal protection equipment, I assume you're going to make them available for your employees, and there's going to be cost to that. So you have to track your costs.
Okay, thank you. And we do have a question that came in through our audience, and that is, who pays for the COVID-19 delays and loss of productivity?
Well, we're going to get to that, but briefly stated, there's two levels. There's time and there's money. It is more likely that you're going to get time as a contractor. In terms of money, we need to look at your contract to see whether or not you're allowed to get money for delay. Also, you're going to have impacts along the line of force majeure that may set up a basis for you to ask for money. So that I would say initially it's going to be an outlay by the contractor with an attempt to get money back out of the owner. And that's going to be dictated largely by your contract language and also by what the courts begin to do with what we're seeing with COVID-19, because that is going to affect what we're able to claim or not claim.
Okay, thank you.
So again, for change orders, you're looking for time and money. And again, the A201 has a specific provision that addresses changes in the work, adjustments in the money, adjustments in time. Then this is initially with time. There's a delayed extension of time under the A201, and it talks about unusual delay in deliveries, unavoidable casualties or other causes beyond the contractor's control, or other causes that the contractor asserts and the architect determines justify a delay. And clearly COVID fits within the scope of that, and that's going to be something that has to be considered. If it fits within that scope and the architect makes that determination, the way the A201 is written, it's a shall. It's something that should be done, has to be done. So it'll be extended for a reasonable time as the architect may determine. And so that puts the architect directly in the soup for dealing with this. And so they are going to have to, I believe, work closely with the contractor to understand how this is going to impact their schedule. And again, you would make a claim for the additional time under the A201. You have to give notice that you're asking for additional time, and that's to be given with a reasonable estimate of cost and probable effect. And this notice needs to be given before you actually would perform the work. And so the good news is if you have an impact and it's a continuing impact, you only have to give notice once. Then are you entitled to money, which we've been asked. Basically, the AIA punts on this one, I think. They don't preclude recovery of damages for delay. They don't provide for it, but they don't prohibit it. In most contracts in today's world, you're going to see a no damages for delay clause. And so that would, on its face, again, block the ability to get money for delay. And that's going to be something that's going to get litigated, but has not yet. But again, it depends on the language of your contract, how much you're affected by that language when you go to try and get money.
Dave, we have another question that came in from the audience. And that is, can you comment on how a GC should handle an owner's request to execute a change order in which the GC is requested to indemnify the owner for any COVID-19 claims by the GC's employees?
It's interesting. The indemnity would generally cover this even if you don't get an amendment for it, because it's a loss arising out of the work typically. And I'd have to see your indemnity provision to know for sure. It's something where you're going to get a claim. I don't know that you can protect yourself. If you say, I'm not going to sign that, the owner probably under the existing contract has the ability to ask to be indemnified, and you're going to have a fight as to whether or not it's in the scope. In your case, the owner has specifically said that they want to be indemnified for COVID-related incidents, One thing that I would point out to the owner is that you're uninsured for that. As far as I can tell, and I've talked to a lot of different insurance carriers and brokers trying to find some avenue for my clients where they might be able to get insurance. You will be able to get a workers' comp claim covered, as far as I can tell, although if you talk to the carriers, they're denying that they've processed any yet. But in terms of your CGL policy, there's an exclusion. So this is going to come out of your pocket. And I think one of the ways it's going to be analyzed is whether you knew or should have known that your worker had a COVID issue. Are you doing the screening? Are you asking the questions? Have you preserved the information to protect you so you can say that that person on that date did not have a fever, did not admit to being in a household with someone that had COVID, and therefore there was nothing that you did negligent that led to the problem. I would try and resist signing such a change order because you don't control it. I would be willing to say that you should commit to following all the CDC and the OSHA and the state ordinances that require you to do certain things on your project. But to make you an insurer for a project in case someone gets COVID, I would basically say that when that occurs, that's akin to an act of God. I can't control when someone gets sick. All I can do is be responsible in monitoring. So I would try and push back.
All right.
Sorry.
No, it's okay. Thanks.
Again,
there's one more question if you want to take it before you go on. How much should the construction project delivery method impact strategy and anticipated outcome?
in terms of, is this a follow-up for the same person?
It's not. It's a new question. So how much should the construction project delivery method impact strategy and anticipated outcome?
Well, again, if you're in Pennsylvania and you've got a multi-prime project, I think you're going to have a mess. I think you're going to have a situation where one of the primes is going to have someone test positive. All the other primes don't have a relationship with that prime, so they're going to make a claim to the owner. Then the owner is going to have to deal with this as the hub of the wheel, and I think that that's going to make it trickier. You're also potentially going to have a construction manager involved, and they're going to have a certain level of safety oversight responsibilities. If it's, again, I don't know that otherwise the form of the project delivery system, whether it's design build or if it's a GMP or something like that, that it's really going to make a difference. It's a matter of control. It's a matter of whether or not others share that responsibility regarding safety and control. And that's why I think the multi-prime would probably be the one that is most impacted by this. Okay, and we have another question as well, which actually is a great segue into your next slide. So the question is, the effect to the contract schedule is a delay due to major equipment delivery. The documentation is revised quotes for suppliers before and after SARS-CoV-2. The project has LDs and the customer is requesting payment for the LDs. Can force majeure be claimed to negate this request for payment? Contract is firm fixed price except for force majeure. I can't guarantee an outcome. I would certainly claim force majeure. I would look at again, your contract language. We had talked earlier about how under the A201 you look to acts of God and things beyond your control as a basis to entitle you potentially to more time. So if your contract has language like that, I would try and fit your circumstance into that, because this is an unusual delay in supply, not caused by you, not able to be managed by you, akin to an act of God. And so I would certainly push back hard on that basis. And I would think that you would have a reasonable argument for that, but there's a lot of specifics that would have to be known to take it any further than that.
Okay, thank you. That's all the questions.
Okay. So for COVID, I looked up force majeure in Black's Law Dictionary, and it says it's a superior or irresistible force. And if you're going to claim force majeure, such as in the example we just had, the contractor is going to have the burden of proving that this event was beyond their control. And so then this sort of sets up the question that we just dealt with, which is it beyond your control? And the so a force majeure clause, it's going to allocate risk that's considered beyond your control. The A201 does not include a force majeure clause. The section I read you, 8.3, deals as close as any clause does in the A201 with what would be a force majeure circumstance. Typical force majeure clauses, and if you have one, it's going to help guide your arguments regarding this, but it talks about unexpected events. It talks about other acts of God that can provide a basis to excuse your performance or to give you additional time. And the intent is to provide some measure of relief for things that you can't control. It's almost a basic fairness concept. And we've already covered that.
I think we have one more poll question.
Okay, I skipped you.
That's all right. So I'm going to go ahead and launch the polling, but be interesting to know if anyone has had somebody test positive for COVID-19 on their job site so far. And this one looks like, I'll share it in a moment, but it looks like no is the predominant answer, which is good.
Which is merciful.
Yes. So I'm going to go ahead and share the polling now. So yeah, no, about 69%.
Okay. Okay. So one of the things I want to talk about is, so you need to prepare in the event that you have someone test positive. And this is both for the owner and for the contractor. The architect, to the extent that they get you involved in drafting the contracts and looking at the schedule, you're going to get dragged into a lot of what I've been talking about. I've got too much ground to cover to go into much detail for the architects, but I'm happy to, you can email me questions if there's something that you wished I had addressed that I didn't. But basically, you need an action plan in place. You need to be ready to move on it in case it occurs. You've got potential claims that are going to arise out of that. You're going to have owners that have their business shut down. You're going to have a situation where they have to evacuate part or all of a facility or a project site and have it cleaned. You're going to have claims from other contractors on site. You're going to have a workers' comp claim by somebody, and heaven forbid it's somehow traced to something you didn't do with one of your employees in terms of screening, and your carelessness caused other people to contract the disease. It's something that you're going to have to deal with. You all should be chatting with your insurance carriers to understand the limitations of your coverage. I will tell you, it will not be a comforting conversation. And that's why the government has stepped in, because they don't want the carriers to go out of business. But as a result, also, the contractors need to stand up for themselves, I think, because they can't be the insurers either. There are certain things that need to be done to properly manage and create a safe environment. But to become the insurers for the project, I think, is asking a little much, but time will tell how far that goes. I seem to have skipped a slide. Well, in future projects, when you sit down now to draft a contract or review a contract that you haven't signed yet, you can no longer claim that a pandemic was no longer contemplated. It's clearly part of our world. It's unfortunately going to be part of our world. So you need to consider this when you look at your contract. You'll see places, for instance, the A201 where it talks about illness, and you'll see places where it talks about personal injury. Everywhere that it says personal injury, it needs to be expanded to include illness. You need to include what the contractor's representative does to include things related to COVID-19 or other viruses or microorganisms. You need to look at contingencies and again, requiring ahead of time action plans, both for how you're going to keep your project safe and what happens in the event of an incident. And this is going to require you to look at your contract and consider how these clauses are impacted. And as I said, there's an awful lot of opportunity for cost and delay as a result of what's happening with COVID. And the better your contract addresses it, the better prepared you will be to deal with it. I hope this has been of use to you. I hope it's of interest. People hate contracts, but they become very interesting whenever you're trying to do a change order, or if you're in a litigation, then all of a sudden it becomes fascinating reading. But hopefully this has been of help. There's two books I want to promote. I'm chairman of the publications committee for the American Bar Section on construction law. I'm a past member of their governing committee. It's a group of 5,000 construction lawyers all over the country. We get together and discuss issues related to construction law. And we have two books that we've put out. One is the A201 desk book, which goes into great detail on the A201 and provides a lot of commentary and useful insight on the different provisions of the A201. And then there's a new book that just came out on May 28th. It's called the Construction Contracts Book. And this looks at not only the AIA documents, but the consensus docs and the EJCDC documents. And it has the added quality of me being one of the editors. So there's a link that will be on this page that will allow you to get to our to the website to be able to purchase these books. I make no money off of it. I just think that they're very good tools. And with that said, I am done in terms of my presentation. If there's something that anyone wants to talk about, I'm happy to discuss it.
Thank you, Dave. We did have a comment that came in that says, not really a question, but helpful info. We have done extensive research in Texas and elsewhere and believe COVID-19 should constitute a force majeure event under other causes beyond the contractor's reasonable control in 8.3.1. Cases often cite foreseeability.
Yes, and so again, that's good for an existing contract, and then when you now can foresee it and you do your new contract, you're going to have to deal with it. But yeah, I agree. I think that is a good argument. I still question whether you have the ability to control it at a level where it really is fair to saddle the contractor with that going forward. I think you need to look at whether there isn't some other way that we can deal with this that is fairer, if you will.
And I guess I just have a question for you, in that the folks that are primarily on this call are coming from the project side, the project management side. So, you know, they may or may not be intimately involved with the contracts. They may have legal counsel that's handling that. So how do they take this information that you're saying today and address it with their legal counsel?
Well, two things. If they're on the project management side, they absolutely need to have good records regarding impacts and delays and costs. And there needs to be someone that looks at what you're capturing. As the lawyer, I do a lot of litigation. As a lawyer that gets pulled in and I look at the project documentation and it's incomplete, It's very expensive or impossible to recreate it after the fact. So you need to think through your record keeping and make sure that you're capturing useful information that can help you in terms of a change order or a claim or defending a claim. And that's something that you need to look at. In terms of your contract, there's two other things that come into play. One is the indemnity provision that someone raised, and you're going to have to read that in light of what we're dealing with here. But also there's a waiver of consequential damages, which is a good thing because that's going to protect claims from indirect harm and claims that were not foreseeable, and therefore that helps you defense against some of what you're seeing. The other thing before I finish answering Laura's question is that if you have a performance bond, the problem that I'm seeing is that the performance bond doesn't have the same type of exclusions that you see in insurance. So that you may have a circumstance where the contractor has provided a very full protection without any exclusions that you might want to have. And so you may want to talk to your bonding company about when you're going to get a bond in the future, if there's anything you can do to protect you from having that bond cover things that otherwise are not covered by insurance. But in talking to your lawyer or to your claims person or to your contract drafter, I would want them to be very conversant in what's happened with COVID-19. I'd want them to have at least considered some of the issues that we've raised here today to make sure that you're prepared and that you're not trying to create something after the fact, or you're not trying to catch up in the event that there's a claim. And so I think it's a matter of trying to have someone give your contract or your future contracts a healthy read and to understand how they might need to be adjusted.
All right, great, thank you. So we have a couple of questions that came in from the audience. The first one is, what do you see as the long impacts of COVID on construction contracts?
I think it's going to increase the cost. I think that you're going to have to build into your cost the personal protection, the interruptions that are necessary to question and test everybody every morning, to record keep relating to that, to plan for contingencies in the event of someone getting sick, a need for a shutdown, the interruption in terms of procurement. So you're going to have impacts that have to be anticipated and built into your schedule and built into your costs. So I think it's going to drive up costs. It's going to extend the time it takes to do your project. What I've been told in the short run is we're not seeing immediate cost increases like I thought we might, but again, it's early on, and depending on what you're building and where your material or your equipment is coming from, it's going to be impacted differently.
Okay. We have another statement here that says, in new contracts, we are including mitigation responsibilities for the contractor and subcontractors. We see a lot of resequencing of work to comply with CDC, OSHA, and local requirements.
And I think that's a healthy and proper thing. I think having everyone sit down and determine what we're in for, to decide what we can do to minimize it, to plan for it, is in everybody's best interest. We can't be in silos. We can't be so defensive that we're not communicating with everybody and trying to come up with what appears to be your best way through this morass. And so I think I like the concept of mitigation and the concept of working together to achieve mitigation.
And there's another comment from the same individual. It is important to refer to epidemics and pandemics in addition to COVID-19 because a recurrence of the coronavirus may be called COVID 2020.
Yeah, and again, the insurance companies have done that for us. They've called them microorganisms and viruses. And so I think if you take their language, it's going to be broad-based enough that it will address whatever permutation of this terrible thing may exist in the future.
Okay, thank you. If anybody else has any other questions, please feel free to type them into the Q&A feature within the Zoom panel. And if no more questions, then we will go ahead and we got a lot of thank yous for the presentation. Great job, Dave. So a lot of good positive feedback.
Great.
So if you do have any questions, what I've done is I put together a slide here with Dave's contact information. Please feel free to reach out to Dave directly as far as any questions that you might have. I've listed his website, phone number, LinkedIn. Feel free to connect to him on LinkedIn. We also, if you missed, so thank you very much, Dave, for presenting to our customers and to our contacts that are involved with the construction industry, and certainly your contacts as well.
Great. Well, thank you for including me.
Yeah, absolutely. So like I said, this is meant to be a series of webinars that we're trying to kind of give back to our community for companies and dealing with COVID-19. So if you've missed our last webinar and are interested in watching it, it is posted on our website under vpocloud.com//webinars. This particular webinar will be also published as soon as it's available. And then we will also have future webinars. We're trying to hold one every month. So the next one, we're probably going to have a panelist of people that will be talking about how they're dealing with the COVID-19 situation. So more to come on that. If you haven't signed up for our newsletter, please feel free to either sign up or subscribe on our website, follow us on our social media, and if you have any questions, please feel free to reach out to myself as well. So lots of positive feedback, Dave, not necessarily questions, but a lot of positive feedback from your presentation. So again, thank you very much. And thank you everyone for joining us during this time, and good luck to you, and look forward to hearing from you again.
Thank you.
Thank you.